In July 2002, a panel of eminent persons was appointed to conduct a review to essentially develop policy instructions for legislative drafters. It was known as the IT Review and was focused on developing a set of proposals directed to a stated policy objective of limiting liability and damages for negligence, worsening the position of injured persons. In 2004, National Occupational Health and Safety Commission statistics for 2000 and 2001 conservatively estimated the total cost of workplace injury and illness to the Australian economy was $34.3 billion. This is equivalent to 5% of Australia's gross domestic product for that financial year. Disturbingly, only 3% of this cost was borne by employers, 44% by workers themselves, and 53% by the community as a whole. Hello and welcome to today's episode of Beautiful Minds. I'm Elise Bennett. Today we will be reviewing the law relating to negligence liability for personal injury in Queensland and whether it appropriately and sufficiently balances the needs of interested parties and societies in general following the introduction of the Civil Liabilities Act in December 2002. We will critically evaluate the common law position relating to pure psychiatric injury in the workplace and will be joined by Courtney Holmes representing plaintiff lawyers as well as academic Kylie Bruce from a standpoint theory encompassing personal and social perspectives. The loudest critic of the review has been by plaintiff lawyers, and joining me now is Courtney Holmes from the Australian Plaintiff Lawyers Association. Great to have you with us, Courtney.
Thanks, Elise.
Could you please explain what the current state of the law is in relation to psychiatric injury in the workplace? What actually amounts to a workplace psychiatric injury?
Okay, Elise, in order for a worker to prove that they have suffered a purely psychiatric injury in the workplace, they must show that firstly they have suffered from a recognisable psychiatric injury. Secondly, that the illness must have been reasonably foreseen by the employer and also reasonably foreseeable. Thirdly, there must have been an established duty of care. Fourthly, that duty of care must have been breached. And finally, the breach of that duty must have caused the psychiatric injury suffered by the worker.
Courtney, what makes psychiatric injury legally different to physical injury?
Pure psychiatric injury is an injury which is not accompanied by a physical injury. This area has traditionally been a problematic area in the law of negligence. It has been noted that the courts in England and Australia have traditionally applied a restrictive approach for claims for pure psychiatric injury. It has been suggested that this approach has been motivated by social policy considerations.
Okay, we'll actually be discussing that with Kylie Bruce later in the program. I understand that prior to the High Court decision of Tame and the State of New South Wales and Annetts against Australian Stations Proprietary Limited, in order to make a successful claim for psychiatric injury, the plaintiff was firstly required to prove that a person of normal fortitude would have suffered the injury. Secondly, that the injury arose from a sudden or nervous shock. And finally, that the injury arose from directly viewing the event. So, Courtney, could you discuss the landmark decision of Tame and Annetts and bring us up to speed with any further developments of the law since 2003?
In the former case, Mrs. Tame developed a psychiatric injury after discovering an error made by a police officer on her accident report form. The error was in relation to her blood alcohol concentration and the fact that it was mistakenly higher than it was in reality. The High Court held that in the circumstances of the case, it was not reasonably foreseeable that Mrs. Tame or a person in her position would have suffered an injury. The High Court also heard a similar case at the same time. In this case, Mr. and Mrs. Annetts' 16-year-old son was working on a remote property in Western Australia. He went missing while he was at work, and upon being informed of the news, Mr. Annetts collapsed. After 5 months of searching for their son, Mr. and Mrs. Annetts were informed by telephone that his remains had been found. Mr. and Mrs. Annetts subsequently developed a psychiatric injury. The High Court held that in the circumstances, it was reasonably foreseeable that persons in the position of Mr. and Mrs. Annetts would have suffered a psychiatric injury. The High Court considered that the relationships between the plaintiff, Mr. and Mrs. Annett, and the defendant, Australian Stations, as well as both of their relationships with the victim, gave them grounds for the case.
Right, so what you're saying is essentially it was their relationship to the victim that enabled them to bring the case to court.
Yes, that's right.
Right, so could you tell us why the cases of Tame and Annette's are important to the development of the law in relation to psychiatric injuries in the workplace?
Following the decision of these two cases, it was no longer necessary for the plaintiff to prove that they are of normal fortitude. This case is important, as Justice McHugh noted. The time has come when this court should retrace its steps so that the law of negligence accords itself with what people really do or can be expected to do in real life situations. The case of Tame and Annette's is also important as it allows a plaintiff to bring a claim where they suffered an injury of a psychiatric nature over a long period of time.
Right, so Courtney, I understand that the High Court also considered psychiatric injury in the workplace in the case of Kohler and Cerebos Proprietary Limited. What eventuated in that case?
In this case, Ms. Kohler was retrenched and then re-employed in a different position for the same company. She was essentially performing the same duties as in her original position, but in less hours. Ms. Kohler complained that she was unable to perform the work required. However, she didn't suggest that the difficulties she experienced were affecting her health or that they were as a result of the duties she was required to perform. The High Court held that in the circumstances, the defendant could not have reasonably foreseen that a person in Ms. Kohler's position would have suffered a psychiatric injury. The High Court rejected the notion that any employer should be taken to know that all employees are at risk of a psychiatric injury from stress at work. However, it has been suggested by Kevin Holyoake, a Queensland barrister, that it is general knowledge that some recognisable psychiatric injuries can be triggered by stress at work. This case is important to the development of the law of negligence in relation to psychiatric injuries, as it has clarified the nature of reasonable foreseeability.
Sure. That actually will be discussed with Kylie Bruce in relation to its social policy implications later. So Courtney, what is the significance of the case between Hegarty and the Queensland Ambulance Service in 2007?
Well, Elise, this case was decided by the Queensland Court of Appeal. Mr. Hegarty was an ambulance officer for approximately 15 years. During his employment, Mr. Hegarty was required to attend many traumatic and distressing scenes. He argued that he did not receive counselling, psychological support or treatment in relation to the distress he experienced after attending those scenes. However, Mr. Hegarty had received training and he should have been able to recognise the signs of those work-related stresses. In this case, it was conceded that it was reasonably foreseeable that persons in Mr. Hegarty's position would have suffered psychological stress and possibly psychiatric injury. Yet, Mr. Hegarty's claim failed, as he did not provide notice to his employer that he was suffering from a psychiatric condition and required treatment. This case was important as the court was concerned with imposing a duty on employers to intervene if they considered that an employee was suffering from psychological stress or psychiatric injury. Further, the court discussed that this could be an invasion on the rights of an employee and an infringement on their personal lives. The New South Wales Court of Appeal decided a very similar case a few months ago. In that case, Mr. Doherty was a police officer for 20 years, from 1985. He was required to attend numerous crime scenes involving death or serious injury, and as a result, developed a psychiatric injury. The court held that the state of New South Wales should have foreseen that there was a significant risk of psychological injury to officers involved in crime scene investigation, and that this psychological injury could be very serious. As such, the court held that there should have been a high standard of monitoring of these officers. The court also considered the fact that some of these officers would tend to disregard or minimise their symptoms so that they could continue to perform their duties. Accordingly, Mr. Doherty had his claim discounted by 35% for contributory negligence.
Thank you, Courtney. We are pleased to have with us now academic Kylie Bruce, who will discuss relevant policy and social effects from the standpoint theory of psychiatric injury. Thanks for coming today, Kylie.
Thanks. It's great to be here.
So, Can you tell us how you actually view the current state of the law relating to psychiatric injury in the workplace?
Thank you. The law of negligence and psychiatric injury is influenced by social, economic and political values in the same way that society is influenced by the law. The current state of the law does not sufficiently balance the needs of plaintiffs. It actually tends to favour the needs of employers over the employees in the workplace. This imbalance is compounded by society's subjective perspective of psychiatric illness.
These policy issues relating to the umbrella concept of foreseeability, it's really a balance to see whether precautions have been taken. Kylie, what's your take on the decision in Tame and Annette's that we discussed with Courtney Holmes earlier in the program?
In the judgment of Tame and Annette, Gummo and Kirby made the following observation regarding the distinction between physical and psychiatric harm. They said that psychiatric harm is less objectively observable than physical injury and therefore more likely to be trivial and fabricated, or is more captive to shifting medical theories and conflicting expert evidence. The litigation in respect of purely psychiatric harm is likely to operate as an unconscious disincentive to rehabilitation. Their third point was that by permitting full recovery for purely psychiatric harm, this risks indeterminate liability and greatly increases the class of persons who may apply.
It all appears to be restricting the type of person that can actually bring a claim for psychiatric injury in the workplace. Is there some kind of fear of opening indeterminate liability and opening the floodgates to every man and his dog?
There is a lot of fear around mental harm, psychiatric injury. There always really has been.
So if something isn't recognised under the DSM-4, you can't claim for it, can you? So
that is potentially another way that they could restrict. However, the medical profession, and I actually took this point further with Dr. Julius Petrov, who does actually work with those with psychiatric injuries. He is a psychiatrist. The law likes the clinical psychiatrist, clinical psychologist perspective with this. That was outlined in the IP report. And the reason being is because they have a medical degree, but there, to a certain degree, yes, unless you have a psychiatric injury that does fall within the DSM-4, then you are precluded. The DSM-4 is very sensitive and is also it's very accurate. I spoke with Dr. Julius Petrov also about the allegations of malingering.
And what is malingering? Why is that important?
Well, malingering refers back to the indeterminate liability. And the IP recommendations, well, one of the points of references was to confine the ability to claim.
Right. So we're seeing
to restrict. What we saw was indefeasible liability being strangled. And because of the subjective, objective nature of psychiatric injury, unfortunately, this has been one of those areas, with the exception of the High Court recognising commercial contexts, as it always will, the public arena of psychiatric illness, not the personal injury, the tortfeasor afflicting on mental harm.
So what you're saying is, say, for example, in the Tame and Annette's case, had it not been for that contractual commercial relationship where the mother was guaranteed by the carer of the son that he would be looked after, she may not have been able to get her case to court.
Definitely. From my perspective, the relationships become very much the policy considerations in that case for today. And the relationships that were favoured were those of a commercial context where the employer actually gave assurances. Kohler was the same. Unfortunately, Kohler, she had signed a contract that outlined duties. Because she had done so, the court found there was not, even though they did consider the duty, there was not fault on the employer. Now, Kohler is interesting because there was other statutory legislation involved. There was anti-discriminatory legislation, there was the workers' compensation, and really for the court to only look at those perspectives rather than psychiatric harm in isolation and the effect it had. We've not reached really where we think we've reached.
So there is a need for reform to improve the position, even though Queensland is currently, as you say, sitting probably in the best state comparatively with the rest of Australia. There is still room for improvement.
Arguably, since Hegarty, we have the decision in Hegarty referring to, and Justice Keane referring to, that there isn't the duty on the employee to inquire, or there is that wall of not wanting to break the privacy of employee and inquire as to whether, how are you feeling about seeing these traumatic events? Are you feeling, is there, so what we're saying therefore is that we're valuing the employer's responsibility not to intervene against, let's say, somebody who could potentially be suffering from a severe psychiatric illness.
Sure.
And we're not doing the same for physical injury. Just Julius Petrov also talked about the secondary gains that a plaintiff can get. It's not just financial, that there is the nurturing requirements, there is the help, there is the support in the workplace that could potentially help with and assist with overcoming the mental illness.
So the social effects of these policies that they're using are actually, it's not just financially orientated.
No, and it's quite wonderful that it does come out in these decisions, that we do see in negligence law that the policy is discussed. Kirby, we've seen here run quite a, if I might say, a conservative line, because he talks about full recovery for psychiatric harm, risks indeterminate liability, and greatly increases the classes. So we bring that the floodgate myth in there. And I tend to hold that it is unlikely within any area of medicine or injury that there's going to be an employee standing up saying, excuse me, look, I'm your employee, I'm begging your pardon, this negligent act that you have done has given me a psychiatric injury, I now want money from you. Not only that, given the fact that I'm unable to work anymore, how am I going to pay to get to court?
Kylie, who determines what's normal? What standard do they use? Is it the same for physical injury?
Since the decision in Thames and Annette's and the requirement for normal fortitude, we see this element of foreseeability now being normal fortitude. It's coming under more so causation. Causation involves a normative principle, which is whether it is reasonably foreseeable that a person of normal fortitude would have suffered in the same way. Normal, reasonable, and objective persons are qualitative states and are very much creatures of the law. So we see the concept of reasonable person transmuted into the nervous shock arena to a person of normal fortitude. And in earlier cases, it appears that the judges thought that a person of normal fortitude would not have a miscarriage as a result of a serious fright. In the same way, let's say the World War I soldiers who suffered shell shock, the psychiatric harm from extreme fear and psychiatric pressure overwhelming them. Vine's Sanroque Rumble in 2000 document a feminist legal critique, and whether this remains still an area only for the feminist critique issues, or whether it is now encompassing, let's say, the more sensitive aspects of men, where the law still tries to extrapolate masculinity across all boards. So I really feel for industries that are like constructions, or let's say males that in our world see quite traumatic events where they're expected to live up to a reasonable a standard of normal fortitude, where they would not react to these events and have quite normal responses. The Queensland Government is currently conducting a mental health promotion, prevention and early intervention program between 2007 and 2017. It's not overtly compulsory for workplace to implement some of the programs that we would like to recommend to address issues of psychiatric injury in the workplace. As a community, we spend a great deal of time at work, and we believe that an effective program could be promoted throughout workplace channels. This may serve to counter the stigmas of abnormality, irrationality, and the alleged malingering attached to mental illness. The law holds the power to define how we perceive ourselves in the context of society. The law is reluctant to recognise pure psychiatric injury as a compensatable harm. Special tests need to be satisfied to prove psychiatric injury that are not prerequisites for physical injury. This stigmatises mental illness, and on the whole, it questions the validity of psychiatric illness. Psychiatric injury is differentiated from its forerunner, physical injury, and they're not on equal footing when it comes to the defendants owing the duty of care. This, we argue, is one of the biggest constraints that those suffering a psychiatric injury are confronted with today.
Kylie, can you now explain to me how psychiatric injury actually fits in with disability jurisprudential theory?
I'm really pleased to see the Productivity Commission report released in 2010 that there's going to be some long-term assessment of disability care and support going to be happening. And I'm now going to refer to the Physical Disabilities submission, the Productivity's Long-Term Disability Care and Support Scheme, where Fiona Kamari Campbell has made some interesting submissions with regards to psychiatric injury here. See, the physical disability concerns encompass mental health conditions, and we believe, or this submission believes, that mental health should be contained with the National Disability Insurance Scheme. Otherwise, this can be a further area where inconsistencies may occur between states and also with regards to the services that will be offered. So the National Disability Insurance Scheme does really look at alternatives to the common law full play in Queensland, and these are dynamics happening currently. There is a significant push for this type of reform, because since the Commonwealth Disability Discrimination Act, Section 4, we're seeing a reinvention of, let's say, with this new submission and the call for those with disabilities, their participation in response to how the Act and even how disability is conveyed and seen within the community. It very much relies on the biomedical model.
And that's very important. It seems to be that this biomedical, the dependence on a medical definition to substantiate or quantify a psychiatric injury, it always seems to be determined by what the disability is, the lack of ability, the deviation from the norm, based on the normal fortitude and reasonable objective test that you were mentioning before. So what implications does this have for reform and implementing the IP recommendations?
Yes, it's another, getting mental illness or even mental illness on the plate of disability has been a bit of a feat because of the subjective nature of it. One aspect of the biomedical approach of disablement has been the invention of the concept of normalcy. And really we get back to the judiciary's obiter, and we see it in the decisions. These principles relating to objective, normal standards, normal fortitude. And this normative constitutes an opposite, like a pathology or pathological. In law, this aspect can be found in, like I said, the reasonable person, and a requirement that people be fully human.
Thank you for your time today. We really appreciate you coming into the show.
Thank you, Elise.
The primary commentary from the development of law is that the Civil Liability Act in 2003 does not apply to psychiatric injuries arising from workplace incidents. However, recent amendments to the Workers' Compensation and Rehabilitation Act 2003 mean that sections 305B to 305E of that Act mirror sections 9 to 12 of the Civil Liability Act. These sections are related to breach of duty, standard of care, causation and onus of proof. These reforms were only introduced as at the 1st of July 2010, and at present there have been no decisions of the court handed down which discuss these amendments in relation to psychiatric injuries. Taking all this into consideration, it brings the question, who is responsible for the psychiatric wellness of the employee? Is it the employer? Or does the employee as an individual have to take responsibility for their well-being? Or does the community have a responsibility to change their perception on the subject? This brings us to the end of the program. I'd like to thank our guests for their time here today, and I hope you've all been enlightened on the subject of psychiatric injury in the workplace, and we can work towards improvements in the future. I'm Elise Bennett. See you next time.